What is NY VTL Section 1192, 2A, Aggravated DWI in New York? Driving with a blood alcohol content of 0.18% or higher or with a child passenger in your car can lead to aggravated DWI charges under New York law. Aggravated driving while intoxicated under New York Vehicle and Traffic Law Section 1192, 2A, applies when your blood alcohol content is at least 0.18%. Another form arises under Leandra's law when a driver operates a vehicle while intoxicated with a child 15 years old or younger. Both versions carry harsher penalties than standard DWI and limit plea bargaining options. A standard DWI requires a BAC of 0.08% or higher, while aggravated DWI per se requires 0.18%. For a first offense based on high BAC, fines range from $1,000 to $2,500 and the license revocation is at least 1 year. If a child passenger is involved, the charge is an automatic Class E felony even for a first offense. In comparison, a first standard DWI carries fines of $500 to $1,000 and a 6-month license revocation. Aggravated DWI severely restricts reductions to the lesser offense of driving while ability impaired and generally requires at least a plea to a standard DWI. The New York Department of Motor Vehicles requires installation of an ignition interlock device for at least 6 months and often 12 months when convicted of aggravated DWI. A second aggravated DWI within 10 years is a Class E felony punishable by $1,000 to $5,000 in fines, up to 4 years in state prison, and a mandatory license revocation of at least 18 months. A third offense becomes a Class D felony with fines from $2,000 to $10,000 and up to 7 years in prison, and it can lead to permanent license revocation. Given these escalating penalties, anyone facing an aggravated DWI should consult with a defense lawyer promptly. Defending an aggravated DWI often involves challenging the traffic stop and questioning the accuracy of chemical tests. Lawyers may argue that police lacked a legal reason to stop the vehicle or that the breathalyzer was not properly calibrated. They can challenge blood test procedures for errors in collection, storage, or analysis. Medical conditions and certain medications can produce falsely elevated breath test results. Attorneys also contest field sobriety tests and raise Miranda rights violations when questioning occurs without proper warnings. Aggravated DWI charges are harder to reduce because prosecutors are limited in offering non-criminal pleas, but a reduction may be possible if evidentiary problems exist. After an aggravated DWI arrest on Long Island, act quickly to protect your rights. You may request a hearing to challenge the prompt suspension of your license, and deadlines are short, so immediate action is crucial. Write down everything about the arrest, including why you were pulled over, the tests administered, and whether you were read your Miranda rights. Avoid discussing the case on social media or with anyone other than your attorney because statements can be used against you. An experienced attorney can guide you through these procedures and communicate with law enforcement and the court to protect your interests. Aggravated DWI is one of the most serious drunk driving offenses in New York and can lead to steep fines, long license revocations, jail or prison time, and a lasting criminal record. Whether your charge results from a high BAC or a child passenger, the consequences can follow you for years. Our law firm stresses that acting quickly with a knowledgeable lawyer improves your chances of a favorable outcome. The law offices of Jason Bassett, PC, is a law firm serving Suffolk and Nassau counties and can provide a free consultation to review your case. You can visit the law offices of Jason Bassett, PC at 320 Carleton Avenue, number 4200, Central Islip, New York, 11722. United States, or call them at 631-259-6060.